Good evening. Welcome to this meeting of the Standing Committee on Government Operations. Committee, there's an agenda before us. Can I get a motion to adopt the agenda? Mr. Simpson, all those in favor? Motion carried. The agenda is adopted. Declarations of conflict of interest. Hearing none, we'll move on to today's committee business. Public clause-by-clause review of Bill 29, an act to amend the Access to Information and Protection of Privacy Act, with the Honourable Louis Siebert, Minister of Justice. Today, and first, before going into my opening remarks, I'll allow the committee members to introduce themselves, starting with Mr. Nakamayak.
Thank you. Welcome, Herb Nakamayak from the Nuklut.
Good evening, R.J. Simpson, MLA for Hay River North.
Good evening, Danny McNeely Satu.
Good evening, Michael Nadley, MLA for Dechul.
And I'm Kieran Testart, member for Cam Lake and chair of the Standing Committee on Government Operations. With me at the table are Jennifer Frankie Smith, committee clerk, and April Taylor, committee research advisor, and law clerk of the Legislative Assembly, Sheila McPherson. Today we are this committee is reviewing Bill 29. Bill 29 has been introduced by the Honourable Minister of Justice and proposes to provide for the application of the Act to municipalities that are designated in regulations, clarify the types of records exempted from disclosure because they would reveal cabinet or financial management board confidences, and provide for a similar exemption for municipal records, allow for a compelling public interest to override particular statutory grounds for exemption from disclosure, revise timelines by restating them as business days rather than calendar days, shortening some turnaround times, and adding timelines for some activities that did not previously have timelines, set out a process for the Information and Privacy Commissioner to consider requests from heads of public bodies to extend time limits for responding to requests for access, address the privacy and access considerations related to human resources documents, including employee evaluation and workplace investigation documents, clarify exemptions from disclosure relating to business interests, permit the collection and disclosure of information for the delivery of common or integrated programs and services, update the general powers of the Information and Privacy Commissioner, provide for a review of the Act by the Minister every 7 years, and make other adjustments intended to improve language and enhance clarity in the Act. Bill 29 received second reading in the Legislative Assembly on October 30th, 2018, and was referred to the Standing Committee on Government Operations for review. To commence its review of Bill 29, the committee sent letters inviting input from an extensive list of stakeholders, including all municipal and Indigenous governments in the Northwest Territories, and a number of non-governmental organizations. During the week of January 21st, 2019, the committee traveled to and held public meetings on Bill 29 in Fort Smith, Inuvik, and Fort McPherson. A final public hearing was held in Yellowknife on January 24th, 2019. Committee thanks all those who attended these meetings or provided written submissions to the committee sharing their views on this important piece of legislation. As a result of committee's consultation, committee will be proposing 24 amendments to Bill 29. 3 of these motions are rather lengthy, including 2 that are each 4 pages in length. For the sake of expediency and accuracy, the member will be moving a motion to deem these amending motions read into the record. For members of the public who are present this evening, copies of these motions will be made available once they have been introduced. The details of the submissions received by the committee and the nature of the committee's deliberations will be addressed in our report to be presented in the Legislative Assembly next week. There are copies of the bill available at the back of the room. Committee would also like to take this opportunity to thank the Honourable Minister of Justice and his staff for the collaborative approach on the review of Bill 29. As we proceed with the clause-by-clause review tonight, it can be seen that the motions being put forward to amend the proposed legislation have improved the content of the bill, and that can be attributed to the committee and the department working together to create better legislation for the residents of the Northwest Territories. I will now invite the Honourable Minister of Justice to introduce himself and his staff for the record and proceed with any opening comments you may have. Minister Siebert.
Yes, thank you, Mr. Chair. I'm here with Denise Anderson, Manager, GNWT Access and Privacy.
Office, yes. Access and privacy.
Okay, thank you. Kelly McLaughlin, Legislative Counsel, Mike Reddy, Director, Legislation Division, and Heather Riviere, Ministerial Special Assistant. I'm here today to discuss Bill 29, an act to amend the Access to Information and Protection of Privacy Act. The proposed amendments contained in Bill 29 are intended to improve public accountability, the protection of personal privacy, access to government information, as well as greater transparency and openness. The amendments include lowering fees and shortening time frames for processing requests and arise from recommendations received during the comprehensive review of the Access to Information and Protection of Privacy Act that was completed in 2017. The review involved extensive consultation with public bodies, the Information and Privacy Commissioner, and the public. All feedback received during the course of these consultations, including the Information and Privacy Commissioner's extensive submissions and recommendations previously identified by the Standing Committee on Government Operations, have been thoroughly considered. Specifically, the proposed changes to the Act include changes to update and clarify provisions relating to purpose of the legislation, improve public access to information by responding to changes in technology and shortening timeframes for processing requests, provide greater clarity on existing exceptions and narrowing the focus of specific exceptions, provide for common or integrated services or programs across public bodies, and to provide greater clarity on disclosures supported by the Act, and provide for greater oversight of activities carried out under the Act, including new powers for the Information and Privacy Commissioner. The bill also makes a number of non-substantive miscellaneous amendments to improve the clarity and readability of specific provisions of the Act. I would be pleased to answer any questions members may have regarding Bill 29. Thank you, Mr. Chair.
Thank you, Mr. Minister. Any questions for the Minister? Hearing none, does committee agree to begin our clause-by-clause review of Bill 29? Thank you, committee. We will defer the title of the bill until the end and begin with consideration of the clauses. There are 40 clauses in this bill. We will group the clauses where possible. Please turn to page 1 of the bill. I'll just wait. Everyone's there? Okay. To clause 1, does committee agree?
Agreed.
Thank you, committee. To clause 2, Mr. Simpson.
Thank you, Mr. Chair. Mr. Chair, I move that subclause 2(4) of Bill 29 in the English version be amended in the proposed definition, common or integrated program or service, by striking out one or more other public body and substituting one or more other public bodies. Thank you, Mr. Chair.
Thank you, Mr. Simpson. The motion's in order. To the motion, Mr. Simpson.
Thank you, Mr. Chair. This is known as the more the merrier motion. It changes the singular body to the plural bodies, which is just a typo in the Act. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion. Question has been called. All those in favor? Any opposed? Motion carries. Does the minister concur with this amendment?
Yes, we concur.
Thank you, Mr. Minister. Committee to clause 2 as amended. Does committee agree? Agreed. Thank you, committee. We'll move on to clause 3. Does committee agree? Agreed. To clause 4. Mr. Simpson.
Thank you, Mr. Chair. Mr. Chair, as motion number 2 is more than 1 page in length, I move that this motion be deemed as moved and read as written and distributed to members. Thank you.
Thank you, Mr. Simpson. Motion's in order. To the motion. Question's been called. All those in favor? Motion has been carried. The preceding amendment will be deemed read and distributed to members. I believe members have a copy. Okay. Mr. Simpson, you may proceed with your motion.
To the motion?
Yeah, to the motion.
Thank you, Mr. Chair. So I will speak to the motion, which has been deemed read. Sorry, this is a little confusing. It's the first time we've done this. And so motion 2, clause 4 of the bill adds a new section, section 5.1, to the Act, which provides that the exemption from disclosure for records under Sections 14, 16, 17, and 21 of the Act does not apply where an applicant demonstrates that a compelling public interest in disclosure outweighs the purpose of the exemption. Committee felt that this should not be up to an applicant to prove, and further, that information about a risk of significant harm to the environment or to health and safety of the public should be disclosed to the public regardless of which section of the Act protects the record from exemption. Motion 2 amends this section of the Act to require that the public body disclose any information that is clearly in the public interest because it is about a risk of significant harm to the environment or health and safety of the public. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Further to the motion? The question has been called. All those in favor? All those opposed? Motion carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 4 as amended. Thank you, committee. Moving along. Clause 5, does committee agree? Clause 6, does committee agree? Clause 7, does committee agree? Mr. Simpson.
Thank you, Mr. Chair. I move that Clause 7 of Bill 29 be amended by deleting proposed subclause 11.2 brackets 2 to 11.2 brackets 7 and substituting the following. A review under this section must be held in accordance with Division D of this part.
We missed a motion. Just a moment, Mr. Simpson. We'll do. Okay, thank you. Sorry, thank you for that indulgence. There's a motion on the floor. The motion's in order. To the motion, Mr. Simpson.
Thank you, Mr. Chair. This motion provides that any reviews held by the Information and Privacy Commissioner relating to a request for a deadline extension by a public body must be held in accordance with Division D of Part 1 of the Act, which sets out how reviews are to be conducted. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion? Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes, we concur with motion 4.
Thank you, Mr. Minister. To clause 7 as amended. Does committee agree? Thank you, committee. We'll just take a brief pause.
Mr. Chair, I move that committee return to Clause 4.
Members requested that we return our review to clause 4. Does anyone disagree? All right, Mr. Simpson, we may proceed to clause 4.
Thank you, Mr. Chair. I move that Bill 29 be amended by adding the following after Clause 4. 4.1, the following is added after subsection 6 brackets 3. 4, the identity of an applicant shall be kept confidential by the head of the public body and the coordinator designated under section 68.1 and may be disclosed only to the extent required to respond to the request for access.
Thank you, Mr. Simpson. The motion's in order. To the motion, Mr. Simpson.
Thank you, and I apologize for the confusion. This is a complex bill, as everyone knows. So when the government departments are processing access requests, there's no requirement that the privacy of the requester be protected. This may result in the name of the requester being shared more broadly than is necessary to fulfill the request. Motion 3 amends the bill to require that the identity of a person making an access request be kept confidential and only disclosed by the ATIP coordinator to the extent necessary to respond to the request. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion? Question's been called. All those in favor? Any opposed? Motion carries. Does the minister concur with this amendment?
Yes, we do.
Thank you, Mr. Minister. To clause 4 as amended. Does committee agree? All right, thank you, committee. So we will return to our original place in the review, which was clause 8. Mr. Simpson.
Thank you, Mr. Chair. I move that subclause 8.1 of Bill 29 be amended by striking out may within 10 business days and substituting shall within 10 business days. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Motion's in order. To the motion. Mr. Simpson.
Thank you, Mr. Chair. If a public body receives an access request for a record that is held by another public body, subclause 8.1 of the bill sets out a 10-day deadline by which the public body must transfer the request to the public body that holds the record. Committee agrees with the inclusion of the deadline, but feels that the transfer should be compulsory, not discretionary. This motion amends the wording of the provision from may to shall to make the requirement compulsory. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion. Question has been called. All those in favor? Any opposed? Motion carries. Does the minister concur with this amendment?
Yes, we do.
Thank you, Mr. Minister. Committee, to clause 8 as amended. Does committee agree?
Agreed.
Thank you, committee. To clause 9, does committee agree?
Agreed.
To clause 10, does committee agree?
Agreed.
To clause 11, does committee agree? To clause 12, Mr. Simpson.
Thank you, Mr. Chair. I move that clause 12 of Bill 29 be amended in the proposed paragraph 19B by striking out Aboriginal and substituting Indigenous. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Motion is on the floor. The motion's in order. To the motion. Mr. Simpson.
Thank you, Mr. Chair. Clause 12 of the bill amends Section 19 of the Act to protect the disclosure of information that may be harmful to conservation, including sites having heritage value or Aboriginal cultural significance. Motion 6 amends this provision to change the word Aboriginal to Indigenous to reflect the most current terminology in use by government. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 12 as amended, does committee agree? Thank you, committee. We will deal with the next set in a grouping, clauses 13 to 16. Does committee agree? Clause 17, Mr. Simpson.
Thank you, Mr. Chair. I'd just like to speak to this clause. Clause 17 of the bill adds a new section, 24.1, to the Act protecting labor relations information from disclosure. In considering this provision, committee is concerned that the term labor relations information is not defined in the Act. The committee recognizes that some labor relation information should be protected. For example, information specific to an employee's discipline file. However, wishes to ensure that the range of information which is protected is as narrow as necessary and that the protection is not overly broad. Committee is working with the minister on how to address this concern. We have had a positive and collaborative working relationship with the minister on the bill thus far, and we are confident that some agreement can be reached on this matter in time for the bill to be amended on the floor of the House. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To clause 17.
Agreed.
Does committee agree then? Okay, thank you, committee. We'll move on to clause 18. Does committee agree?
Agreed.
Clause 19. Does committee agree? Clause 20. Mr. McNeely.
Thank you, Mr. Chair. I move that paragraph 20 brackets A of Bill 29 be amended by striking out 45 business days and substituting 40 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. The motion's in order. To the motion. Mr. McNeely?
Thank you, Mr. Chair. Motion 8. One of the purposes of Bill 29 is to shorten the ATIP process for the public. Number 2, Motion 8 amends the timeline for the public body to give notice to a third party of the intentions to give and or refuse access to a record from 45 business days proposed in the bill to 40 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 20 as amended. Does committee agree? Mr. McNeely.
I move that clause 20 of Bill 29 be renumbered as subclause 20 bracket 1 and the following be added after renumbered subclause brackets 2 subsections 27 brackets 3 and brackets 4 are each amended by striking out within 30 days and substituting with 15 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. Motion is in order. To the motion, Mr. McNeely.
Thank you, Mr. Chair. Bill number 9. Motion 9.1, throughout the Act, deadlines for various activities are currently expressed in the calendar days. This creates a problem for public bodies responding to access requests in December because of the traditional government shutdown shortens the number of calendar days for responding to a request. Bill 29 converts calendar days to business days to address this issue. When reviewing the bill, committee realized that there was a drafting oversight which resulted in the deadlines under subsections 27 brackets 3 and brackets 4 from being converted. Motion number 9 converted the deadlines in these subsections from 30 calendar days to 15 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 20 as amended. Does committee agree? Mr. McNeely.
Just one second, Mr. Chair. I move that Bill 29 be amended by brackets A, adding the following after clause 20. 20.1 section 28 is amended by adding the following after subsections brackets 2. Brackets 3, the Information and Privacy Commissioner may initiate a review relating to access to a record without a formal request for a review being received from an applicant or a third party. Brackets B. Adding the following after clause 21.1, section 30 is renumbered as subsection 30 brackets 1, and the following is added after the renumbered subsection brackets 2 on initiating a review under subsection 28 brackets 3. The Information and Privacy Commissioner shall notify the head of the public body concerned. Thank you, Mr. Chair.
Mr. McNeely, your motion is, only part of your motion is in order. We are on Clause 20, and your motion, the motion you attempted to move deals with both 20 and Clause 20 and 21. So I will allow the first part of your motion dealing with Clause 20 to move, to be considered by committee, but not the second one. However, you may raise it again once we reach the appropriate part of the bill. So with that in mind, committee, the motion is to amend Clause 20.1 to the motion. I'll allow Mr. McNeely the opportunity to speak to it once he is prepared himself.
Okay, I move in reference to clause 21.
I'm just gonna go through this first, so, motion. The first part. April, which part would you read? All of it, okay, so just read all of this.
Okay, thank you for your patience.
Go ahead, Mr. McNeely.
Motion 10. This motion amends the bill to allow the Information and Privacy Commissioner to undertake reviews related to access matters on her own initiative without the prerequisite of first receiving a complaint. Committee supports this because it is consistent with the powers given to the IPCs in other jurisdictions to other statutory officers with ombuds-like powers in the Northwest Territories. Committee also supports it because it allows the IPC to look into matters where there may be a systemic problems not related to a single complaint. Clause 28 of Bill 29 gives the IPC this authority for privacy-related matters. Motion 10 provides that this authority also exists for access-related matters. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Question has been called. All those in favor? Any opposed? Motion's carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To Clause 20 as amended. Does committee agree? Thank you, committee. We'll move to Clause 21. Does committee agree? Mr. McNeely.
Thank you, Mr. Chair. I move that Bill 29, Clause 21 be amended by adding the following after Clause 21. 21.1, Section 30 is renumbered as subsection 30 brackets 1, and the following is added after the renumbered subsection brackets 2 on initiating a review under subsection 28 brackets 3. The Information and Privacy Commissioner shall notify the head of the public body concerned. Thank you, Mr. Chair.
Thank you, Mr. McNeely. The motion's in order. To the motion. Mr. McNeely, did you want to speak to this? No? Okay. Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes, I just want to make sure what I'm concurring to here. So the motion was that Bill 29 be amended by adding the following after Clause 21, et cetera? Is that? Okay.
Yes.
Yes, we concur to that.
Okay, thank you, Minister. All right. Yes, sorry for the confusion on that one, but it seems to be sorted now. Committee to Clause 21 as amended. Does committee agree? Thank you, committee. Clause 22. Mr. McNeely.
I move that clause 22 of Bill 29 be amended by striking out within 60 business days and substituting within 90 days. 90 business days, pardon me.
Thank you, Mr. McNeely. Motion's in order. To the motion. Mr. McNeely.
Thank you, Mr. Chair. Motion 12, in conducting its research on this bill, Motion 11 brackets A, as previously mentioned, one purpose of Bill 29 is to shorten the wait times for the public on ATIP matters. The Act currently provides the Information and Privacy Commissioner with 180 days to conduct a review. Bill 29 proposes to shorten this deadline to 60 business days. While committee is generally supportive of the intent to speed up the ATIP process, committee is of the view that this cut to the IPC's deadline is too severe and would have a negative impact on the ability of the office to complete its work. Motion 11, brackets A, amends clause 22 to set the IPC's deadline for completing the access-related reviews to 90 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Question has been called. All those in favor? Any opposed? Motion carries. Does the minister concur with this
Yes.
amendment? Thank you, Mr. Minister. To clause 22 as amended, does committee agree? I believe Mr. Nope, that's right. Thank you. I thought I saw your hand up there. Clause 23, does committee agree? Mr. McNeely.
Thank you, Mr. Chair. As motion number 12 is more than 1 page in length, I move that this motion be deemed as moved and read as written and distributed to members. Thank you, Mr. Chair.
Mr. McNeely, just before you move that procedural motion, could you just speak to which, all right, never mind. I'll, motion, yeah, to the motion. Question's been called. All those in favor? Any opposed? Okay, thank you. So the motion has been distributed, and I'll allow members to speak to it. Mr. McNeely?
Thank you, Mr. Chair. In motion 12, in conducting its research on this bill, committee considered ways to improve the length of the IPC's recommendations, which are non-binding under our current legislation. Committee looked at how information and privacy commissioners in other Canadian jurisdictions conduct their business, including the model set out in the Newfoundland and Labrador's ATIP Act, which was recommended in the submission provided to committee by the NWT's Information and Privacy Commissioner, Ms. Elaine Keenan-Banks. In discussions with the minister and his staff, committee ultimately determined that the approach we support is to give the IPC's order-making powers. This makes the recommendation of the IPC binding upon public bodies and requires a public body to go to court for permission to disregard the IPC's order. Committee agrees with the IPC that it should not be up to the public body to pick up and choose which recommendations to adopt. It also agrees with the Department of Justice that order-making power will impose the level of discipline on IP's recommendation, which will assist public bodies in meeting those recommendations. Motion number 12 amends clause 23 of the bill and sets out the IPC's order-making powers. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Mr. Simpson.
Thank you, Mr. Chair, and I'm going to support this motion. We spent a lot of time agonizing over this. We talked a lot about the so-called Newfoundland model, and I think we've created the NWT model that other legislatures can emulate when they update their acts in the future. So I'd like to thank the committee for the work as well as the cooperation of the Minister's office. Thank you.
Mr. Simpson. Thank you to committee for your hard work as well. To the motion. Question has been called. All those in favor? Any opposed? Motion carries. Does the minister concur with this amendment?
Yes, we concur.
Thank you, Mr. Minister. To clause 23 as amended. Does committee agree? Thank you, committee. To clause 24. Mr. McNeely.
Thank you, Mr. Chair. I move that clause 24 of Bill 29 be deleted. Thank you, Mr. Chair.
Thank you, Mr. McNeely. The motion's in order to the motion. Mr. McNeely.
Motion 12, brackets A. Motion 12, brackets A is a incidental motion which deletes clause 24 of the bill. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Question's been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment? Mr. Minister?
Yes.
Thank you. Thank you, Mr. Minister. To clause 24. You left us in suspense there for a minute. Clause 24 as amended. Does committee agree? Oh, sorry. I'm sorry. Let me rephrase that. Committee to clause 24 as deleted. Does committee agree? Thank you, committee. To clause 25. Mr. Neckback.
Thank you, Mr. Chair. I move that Bill 29 be amended by adding the following after clause 25, 25.1. The following is added after section 42.1 brackets 1. In this section, privacy impact assessment means an assessment that is conducted by a public body to determine if a current or proposed enactment system, project, program, or service, including a common or integrated program or service, meets or will meet the requirements of this part. Privacy impact assessments, bracket 2, subsection bracket 3. A public body shall, during the development of a proposed enactment system, project, program, or service that involves the collection, use, or disclosure of personal information, prepare and submit a privacy impact assessment to the head of the public body for review and comment. Common or integrated program or service, brackets 3. The head of a public body with respect to a common or integrated program or service shall, during the development of the proposed program or service, prepare and submit a privacy impact assessment to the Information and Privacy Commissioner for review and comment. Notification of a comment or integrated program for service, brackets 4. The head of a public body must notify the Information and Privacy Commissioner of a common or integrated program or service at an early stage of developing the program or service. Thank you, Mr. Chair.
Thank you, Mr. Neckback. Motion is in order. To the motion. Mr. Neckback.
Thank you, Mr. Chair. A privacy impact assessment, or PIA, is a tool that can be used by public bodies to assess current or proposed programs and services to determine whether they adequately consider privacy issues in their design. Committee feels strongly that public bodies should be using PIAs and wanted to ensure that a requirement to do so is included in the legislation. Committee feels that this is particularly important given that the Act establishes that public bodies may share the personal information they have collected for the purpose of common or integrated programs and services. Mr. Chair, motion 13 amends the bill to set out requirements for privacy impact assessments to determine compliance with Part 2 of the Act, which deals with privacy matters. Thank you, Mr. Chair.
Thank you, Mr. Neckback. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment?
Yes, concurred with motion 13 as written, yes.
As carried, yes. Thank you, Minister. To clause 25 as amended, does committee agree? Thank you, committee. To clause 26, Mr. Neckback.
Thank you, Mr. Chair. I move that clause 26 of Bill 29 be amended in the proposed paragraph 48Q brackets 4 by striking out adult interdependent partner. Thank you, Mr. Chair.
Thank you, Mr. Nackamayak. Motion's in order to the motion. Mr. Nackamayak?
There's Section 48 of the Act sets out circumstances under which a public body can disclose personal information. Clause 26 of the bill proposed to amend this section of the bill to add a number of new circumstances, including to a surviving spouse, adult interdependent partner, or relative of a deceased individual, where the disclosure is not an unreasonable invasion of privacy. In our research, committee learned that the term adult interdependent partner was borrowed from Alberta legislation. The Adult Interdependent Relationship Act, which was passed in 2002 to legally define same-sex common law relationships outside the definition of marriage. Mr. Chair, committee felt that this language was not appropriate in the Northwest Territories context and learned that it was not necessary, as the word spouse is defined in the Northwest Territories Interpretation Act. Includes common law and same-sex marriages. Finally, motion 14 amends the bill to delete the term adult interdependent partner. Thank you, Mr. Chair.
Thank you, Mr. Nackamayak. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To Clause 26 as amended, does committee agree? Thank you, committee. Clause 27 of the bill. Thank you, committee. Clause 28. Mr. Nackamayak.
Thank you, Mr. Chair. I move that Clause 28 of Bill 29 be amended and proposed subclause 49.1 brackets 1.1 by adding or a correction of personal information after relating to a privacy breach. Thank you, Mr. Chair.
Thank you, Mr. Nackamayak. Motion's in order to the motion. Mr. Nackamayak.
Thank you, Mr. Chair. Clause 28 of Bill 29 provides the IPC with the authority to initiate a review relating to a privacy breach on her own initiative. Motion 15 amends this provision to clarify that the IPC also has the authority to initiate review related to the correction of personal information, which is also a privacy matter under this section of the Act. Thank you, Mr. Chair.
Thank you, Mr. Nackamayak. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To Clause 28 as amended, does the committee agree? Thank you, committee. To Clause 29. Mr. McNeely?
Clause 29.
Yes,
I move that Clause 29 of Bill 29 be amended by striking out within 60 business days and substituting within 90 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. Your motion is in order to the motion. Mr. McNeely.
Thank you, Mr. Chair. Motion 11, brackets B. Just as motion 11, brackets A, amended Clause 22 to set the IPC's deadline for completing access-related reviews to 90 business days, motion 11B, brackets B, amends that 29 to set out the IPC's deadline for completing privacy-related reviews to 90 business days. Thank you, Mr. Chair.
Thank you, Mr. McNeely. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this
Yes.
amendment? Thank you, Mr. Minister. To Clause 29 as amended, does the committee agree? Thank you very much, committee. To Clause 30. Mr. Nackamayak.
Thank you, Mr. Chair. I move that Bill 29 be amended by deleting Clause 30 and substituting the following. 30, Sections 49.5 and 49.6 are repealed and that the following is substituted. Information and Privacy Commissioner to report. 49.5, on completing a review, the Information and Privacy Commissioner shall, A, prepare a written report with respect to the matter, setting out the Information and Privacy Commissioner's reasons for agreeing or disagreeing with the decision of the public body with respect to the collection, use, or disclosure of the individual's personal information and the reasons for the recommendations. B, make an order described in subsection 35 brackets 2, and C, provide a copy of the report referred to in paragraph A in the order of the and the order referred to in paragraph B to the individual who asked for the review and the head of the public body concerned. Decision of head 49.6, within 40 business days after receiving the report and any order of the Information and Privacy Commissioner under section 49.5, the head of the public body concerned shall comply with any order of the Information and Privacy Commissioner. Thank you, Mr. Chair.
Thank you, Mr. Nekomayak. Motion's in order. To the motion. Mr. Nekomayak.
Thank you, Mr. Chair. As discussed under motion 12, brackets A, committee supports amending the legislation to give the IPC order-making power. Motion 12, brackets A, gave the IPC order-making power under Part 1 of the Act, which deals with access to information. And secondly, motion 16 complements motion 12, brackets A, by giving the IPC order-making power under Part 2 of the Act, which deals with privacy. Thank you, Mr. Chair.
Thank you, Mr. Nekomayak. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 30 as amended, does committee agree? Thank you, committee. To clause 31, Mr. Nekomayak.
Thank you, Mr. Chair. As motion number 17 is more than one page, I could read it if you want, in length. I move that this motion be deemed as moved and read and as written and distributed to members. Thank you, Mr. Chair.
Thank you, Mr. Nekomayak. The motion's in order. To the motion. Question's been called. All those in favor? Any opposed? Motion carried. Motion 17 will be deemed read and as it exists in distribution to members. To the motion 17. Mr. Nekomayak.
Thank you, Mr. Chair. In its review of this bill, committee was mindful that a number of recent publicized cases in which private data has been inadvertently made public. The Government Northwest Territories Health Information Act, which deals specifically with access to and privacy of personal health information, has provisions dealing governing how public bodies must deal with the privacy breaches. Committee believes that the similar requirements should be put in place for all personal information held by public bodies to ensure that data breaches are dealt with proactively. And finally, motion 17 amends the bill to add the new division E of Part 2 of the Act. This new division addresses how the Government Northwest Territories must deal with data breaches. Thank you, Mr. Chair.
Thank you, Mr. Nekomayak. To the motion.
Question.
Question has been called. All those in favor? Any opposed? Motion is carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. Committee to clause 31 as amended. Does committee agree? Thank you, committee. Next, we will do a group, clauses 32 to 35. Does committee agree? Thank you, committee. To clause 36, Mr. Natalie.
Chair, I move that clause 36 of Bill 29 be amended by adding the following after proposed subclause 68.1 bracket 2, bracket 3. The head of a public body shall ensure that contact information for the coordinator designated under subsection bracket 1 is made publicly available.
Thank you, Mr. Natalie. The motion's in order. To the motion.
Thank you, Mr. Chair.
Mr. Natalie.
Thank you, Mr. Chair. The motion is, as number 18, is a small amendment that requires the heads of public bodies to ensure that the contact information for their ATIP coordinators is publicly available. Must see, Mr. Chair.
Thank you, Mr. Natalie. To the motion. Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To the motion, to clause 36 of the bill as amended. Does committee agree? Thank you, committee. We'll move on to clause 37. Does committee agree? Mr. Natalie.
Thank you, Mr. Chair. Mr. Chair, I move that clause 37 of Bill 29 be amended by deleting proposed subclauses 72 bracket 1 and substituting the following 72 bracket 1, the head of a public body shall, bracket A, establish categories of records that are in the custody of under the control of the public body and that do not contain personal information. to be made available to the public without a request for access under this act, and B, publish any categories of records established under paragraph bracket A.
Thank you, Mr. Nadley. Your motion's in order. To the motion, Mr. Nadley.
Thank you, Mr. Chair. Motion 19, Clause 37 and Bill 29, Bill 29 proposed to require public bodies to establish categories of records that can be made available to the public without the need for an access request under this act. The clause proposed that these categories of records be made available on demand. Committee was concerned that the public would not necessarily know which categories of records are available, and without this knowledge would not know what to demand. Motion 19 amends this provision to ensure that the categories of records are publicized so that the public has easy access to information about what records they may obtain without an access request. Must see, Mr. Chair.
Thank you, Mr. Nadley. To the motion? Question has been called. All those in favor? Any opposed? Motion carried. Does the minister concur with this amendment?
Yes.
Thank you, Mr. Minister. To Clause 37 as amended. Does committee agree? Thank you, committee. Clause 38. Mr. Nadley.
Thank you, Mr. Chair. I move that Clause 38 of Bill 29 be amended by bracket A, striking out the period at the end of paragraph bracket B, and substituting quote and, unquote, and bracket B, adding the following after paragraph bracket B. C, by adding the following after paragraph bracket J. Bracket J1, respecting the requirements in the event of a data breach under Division E of Part 2.
Thank you, Mr. Nadley. Your motion's in order. To the motion.
Let's see, Mr. Chair. Motion 20, as previously noted, Motion 17 amends the Act to include provisions governing data breaches. Motion 20 amends Section 73 of the Act, which sets out the minister's regulation-making authority so that the minister may establish regulations related to the requirements for dealing with data breaches.
Thank you, Mr. Nadley. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Minister, do you concur?
Yes.
Thank you, Mr. Minister. To Clause 38 as amended. Does the committee agree? Thank you, committee. To Clause 39. Does committee agree? Mr. Nadley.
Thank you, Mr. Chair. I move that Clause 39 of Bill 29 be amended, deleting proposed Clause 74 and substituting the following. 74, this act must be reviewed by the minister within 18 months after the commencement of the 20th Legislative Assembly and within 18 months of every second Legislative Assembly thereafter.
Thank you, Mr. Nadley. Your motion's in order. To the motion. Mr. Nadley.
Must see, Mr. Chair. Motion 21, Clause 39 of the bill amends the Act to require the minister to conduct a review of the Act every 7 years. Committee supports the inclusion of a requirement for a review so the ATIP Act does not wait 20 or 30 years before it is updated again. Based on its own experience with statutory reviews of legislation, committee is concerned about the timing of the review. When a statutory review is pegged to an arbitrary number of years, the timing of the review may not coincide with the life of a legislative assembly. This means that there is a risk that once a review is completed, there may not be time to enact legislative change before an assembly ends its term. Motion 21 amends the timing of the minister's review such that it is linked to the term of every alternating assembly. This will result in a review being conducted once every 8 years and will allow time for the review to inform legislative amendments. Mr. Chair.
Thank you, Mr. Nadley. Yes, Mr. Simpson.
To the motion. I think this is a good amendment, and I support the motion, and I hope that government takes note of this, and moving forward, this becomes a best practice in terms of the timing of reviews, because we run into some issues, and, you know, a review could come right at the end of an assembly, and then nothing happens with it, and then you could be another 7 years. So I think that, I hope that the drafters take note, I hope Justice take notes, and I hope that in the future, this is the type of drafting that we see. Thank you.
Thank you, Mr. Simpson. To the motion? Question has been called. All those in favor? Any opposed? Motion carried. Minister, do you concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 39 as amended, does committee agree? Thank you, committee. Okay, I will return to clause 39. Mr. Natalie.
Thank you, Mr. Chair. Mr. Chair, I move that Clause 39 of Bill 29 be amended by renumbering proposed Clause 74 as subclause 74 bracket 1 and adding the following after that renumbered subclause. Bracket 2, the minister shall table in the Legislative Assembly report on the results of a review conducted under subsection bracket 1 at the earliest opportunity.
Thank you, Mr. Natalie. Your motion's in order. To the motion, Mr. Natalie.
Let's see, Mr. Chair. Mr. Chair, motion 22 complements the previous motion by adding a requirement for the minister to table a report on the statutory review at the earliest opportunity.
Thank you, Mr. Natalie. To the motion? Question has been called. All those in favor? Any opposed? Motion is carried. Mr. Minister, do you concur with this amendment?
Yes.
Thank you, Mr. Minister. Now, I will call clause 39 as amended. Mr. Simpson.
Thank you, Mr. Chair. Mr. Chair, I move that Bill 29 be amended by adding the following after Clause 39. 39.1. The following is added after Section 74. 75.1. Every public body that is subject to this Act shall, within 60 business days after the end of the fiscal year, report the following to the Minister. A. The number of requests made under this Act received by the public body in the fiscal year. B. The time taken to process the requests. C. The number of requests that were denied and the exceptions that were relied on by the public body. D. The amount of fees collected. E. The justification relied on for any extension of time. F. The number of privacy impact assessments the public body has conducted in the fiscal year. 2. The minister shall table in the Legislative Assembly a report containing the information reported by every public body under subsection 1. A. Within 60 business days after receiving the reports under subsection 1. Or B. During the next sitting of the Legislative Assembly if the Legislative Assembly is not sitting on the expiry of the period referred to in A. Thank you, Mr. Chair.
Thank you, Mr. Simpson. Your motion is in order. To the motion, Mr. Simpson.
Thank you, Mr. Chair. Motion 23 is also about reporting, but it has to do with the day-to-day activities of public bodies related to ATIP legislation. The motion sets out the types of information to be included in their annual reports, which must be provided to the minister. It also requires the minister to compile this information into a report to be tabled annually in the Legislative Assembly, and this type of information is needed so that not only the public but the departments can see what type of requests are being made and tailor the way they do business based on that information. Thank you, Mr. Chair.
Thank you, Mr. Simpson. To the motion. Question has been called. All those in favor? Any opposed? Motion is carried. Minister, do you concur with this amendment?
Yes.
Thank you, Mr. Minister. To clause 39 as amended, does the committee agree? Thank you, committee. Long clause. To clause 40 as agreed. Does committee agree? Thank you, committee. We'll now return to bill number and title, Bill 29, an act to amend the Access to Information and Protection of Privacy Act. Does the committee agree? Thank you, committee. Does the committee agree that Bill 29, an act to amend the Access to Information and Protection of Privacy Act, is now ready for consideration in committee of the whole? Mr. Simpson.
Thank you, Mr. Chair. I move that Bill 29, an act to amend the Access to Information and Protection of Privacy Act, be reported to the Assembly as ready for consideration in Committee of the Whole, as amended and reprinted. Thank you.
Thank you, Mr. Simpson. There's a motion on the floor. All those in favor? Sorry, to the motion. Question has been called. There we go. All those in favor? Any opposed? Motion carried. Bill 29, an act to amend the Access to Information and Protection of Privacy Act, will be reported to the Assembly as ready for consideration in Committee of the Whole, as amended and reprinted. Thank you very much, committee members. Thank you, Minister. Thank you to your officials, and thank you to members of the public. And I'll take this opportunity to recognize that we are joined by the Information and Privacy Commissioner tonight, Ms. Elaine Keenan-Banks, and it's very much appreciated your assistance in both assisting the government in drafting the legislation with your suggestions and the committee with your review. I also do want to take the opportunity again to thank the minister and the government for working diligently with the legislative branch to ensure the success of this process tonight. As interested members of the public may know, this is the second extension the committee received in working on this legislation, and I think tonight showed just how much work was going into this process. But I think we do have world-class legislation that's going to cause the rest of Canada to sit up and take notice of how open and transparent this government really is. So thank you again for your work. Minister, would you like to close with any remarks, Mr. Minister?
Yes, I'd like to thank everybody here and under the table behind me for all the work that they've done. It's been a particularly long day. It was difficult numbering and renumbering or examining the numbering of the sections and making sure that everything was in order. But because such good trust exists between us, I was confident that we could move forward. So it's been a long day, new suit, but still old Siebert. So thank you.
Thank you very much. Thank you very much, Mr. Minister. And before we conclude, I just want to let any members of the public know that the committee intends to report on its review of Bill 20. Oh, sorry, that the review of Bill 29 will be tabled in the Legislative Assembly next Tuesday, and that will be our substantive report that deals with some of the issues we've heard, some of the issues we've been studying, and we'll make recommendations to government as well. And that will conclude our work on this topic. So again, thank you very much. Have a good night. We are adjourned.